Thank you so much for listening in to us. Honorable Nelly Kipchirchir, good morning.
Good morning to you.
How are you doing?
I'm well, I thank God.
Welcome to the show.
Thank
You work with children.
you. Yes.
Yes. And yesterday, as I spoke to Professor Sarah Kinyanjui, who's going to join us later on, she said there's a rising trend in child offending. Before we talk about the rising trend in child offending, what does it mean? What is child offending?
Okay. Thank you very much, and thank you for having me this morning. Child offending is when a child is in conflict with the law.
Yeah.
We have two ways a child can interact with the law. There's one where we called a child offender. A child offender is any person below the age of 18 who gets to break the law. Then we don't call them criminals.
Yeah.
Neither do we call them accused persons. We call them a child in conflict with the law. Then a child in contact with the law is a child victim, a child who has come into the legal system as a result of having been offended. So that's a child in contact with the law. Yes.
Oh, that's a good breakdown. So a child in conflict with the law is a child who, and again, you don't call them criminals.
Neither do we call them accused persons. In our court, we call them a subject.
Yeah.
A subject or a child in conflict with the law.
Yes.
Yeah.
Okay. And then the other one is a child
in contact
with the law.
Yes.
Now huyo ni yule mwenye amefanya makosa.
Hapana.
The victim.
Offender, child in contact with the law ni yule ambaye amekosewa. Na kwa sababu ya kukosewa sasa amepata kutangamana na sheria. Ilhali yule mkosaji ndio anaitwa child in conflict with the law. Amevunja sheria, haiti mshtakiwa.
Yeah. So what is categorized under child offending?
Child offending,
yeah.
If you break the law and you're a child,
okay,
then you are a child offender. You become a child in conflict with the law. So basically anything. If I steal your pen, if you commit assault, if it's robbery, defilement, any offense under the law,
yeah,
only that it is committed by a child, including murder, even manslaughter.
Yeah.
But now in the children court, we don't deal with murder. We deal with all other offenses except for murder, which now has to go to the High Court.
Okay.
Yes.
And in the children court, what cases would you say are rampant?
Okay. Let me speak for the Tononoka Children's Court.
Yes.
The most rampant offense, and it would shock you, is defilement. And defilement is defilement between children. Yes. This is, remember, we are dealing with children generally. So there is no adult here. Sio ati kwamba mtu mzima amemnajisi mtoto. Those ones are in other courts. Sisi tunaongea kuhusu watoto wanao najisi watoto wenzao.
Yeah.
You get?
Yeah.
So, and that defilement is not only it includes sodomy, if I may. Yeah. So the definition of defilement under the law covers defilement of any private genitalia, both the anal and the vaginal. So that is the rampant offense we have. So if you were to break it down and say, we are breaking down defilement into two, into sodomy, quote unquote, and now this other normal kind of defilement that people talk about, you'd find that amongst the children within this region, the defilement of sodomy or gang defilement, that one takes the bigger chunk amongst children and children. Not adults and children.
Oh my God.
Yeah, that's the trend. And the next top offense would be stealing, and followed by robbery with violence. These ones we call vijana wa mapanga. Yeah.
Yes, I top.
No, vijana wa mapanga does not top. I think over the past few years, there's been a lot of sensitization and community reaching out activities by community-based organizations, NGOs, trying to sensitize these young men. So if you find, I don't know, maybe because some of them don't get to court, but the number of those that get to court, the quote-unquote vijana wa mapanga, is lower than defilement.
Nelly,
Yes.
I want to take you back to child defilement. And you're saying it's between children.
Yes.
Where is this coming from?
It's coming from society.
How?
It's coming from schools. It's coming from the community. It's coming from... Okay, let me give you how children cases go
Yeah.
before we now get to know where is it coming from,
Yeah.
right? When a child is arraigned in court, the first thing, the duty of the court is to appoint an advocate who is called a pro bono advocate. Because the law says that a child cannot represent themselves.
Yeah.
So we have to get an advocate for them. After an advocate is appointed, then the prosecutor finds out, has a social inquiry report be done, because there is a new Children Act in place that requires that before a child gets to court, there are things that must be done. A children officer must be informed.
Yeah.
And remember, we have very few of these children officers. So a children officer must be informed. And once they come to court, if a children officer has not prepared a report, then the court says, let a report be prepared. Now, that is called a social inquiry report, with a view to seeing what informed this offense before we deal with the child. Because the way we deal with children is not the way we deal with adults.
Yeah.
You cannot come to a children court, unaambiwa, unasomewa mashtaka, like...
Yeah.
We first must find out the background. So that is called a social inquiry report. Now, can I say 90% of these social inquiry reports, you'll find out that the offender comes from a broken family. Hardly do we find offenders from a working family background. You'll find either the mother and the father separated, or the mother has gone to Saudi, or the father lives in another place, the mother lives in another place, and the mother is remarried, or the father is remarried, and now this child is left in the middle of things, not knowing whether what they are doing is wrong or right. Yeah. So they end up offending, maybe due to lack of proper guidance, or proper family upbringing. So they think that, or in their own way, they find that friends are better, are a better, can I say, a safer nest for them than the adults, because there's no adults like monitoring what they're doing. So they end up getting into the wrong company, getting the wrong peer pressure, the wrong thinking, and maybe getting into not so good conversations. Yeah.
Okay. That is very hard to listen to. And what would you tell me when you're talking about child offenders? Are you able to give a range when it comes to age, the age bracket?
Yes, I can. And maybe before I do that, the age of criminal liability in Kenya was raised from 8 to 12.
Okay. What does that mean?
That means that if child ABC is 11 years, 9 months, and commits an offense, they have not done, they don't understand what they are doing, quote unquote, according to the law.
Okay.
If they are 12 years, they also don't understand what they are doing. So any child below the age of 12 is not criminally liable. So they cannot be arraigned in court.
Oh.
What?
Oh.
Hawajukumiki kisheria.
Kupelekwa mahakamani.
Yes. Hawezi kupelekwa mahakamani wanaweza fikishwa, but kwa njia ambayo nitakuelezea.
Okay.
But yani hawajukumiki kisheria. Hawataandikiwa mashtaka na kiongozi wa mashtaka. Yule ODPP will not now charge them maybe for this and this offense. however how serious it is, the law says they are not criminally liable. The law goes on to say that if the child is between 12 and 14,
Yeah.
the court must find out whether this child understood what they were doing at the time the act was being done.
Yeah.
So hata tukaletewa maybe kijana wa mapanga
Eh,
ako na umri wakati ya miaka 12 na 14, lazima kwanza tufanye utafiti. Je, huyu mtoto alikuwa analewa akichukua panga akimdhulumu mtu ama mwenzake ama akiiba, alikuwa anaelewa yale ambaye alikuwa anafanya?
Yeah.
Sasa hapo ndio other stakeholders come in. Kwa mfano maybe a child psychologist,
Yes.
we work with them. Go to a child psychologist, children officer, they do some sort of finding out, because wakati mwingine unapata kwamba si kosa lake la kwanza, ilhali ako between your age ya 12 and 14. So probably we will conclude that this child understood what they were doing. Then now we move to the next stage. So back to your question of the ages of these offenders.
Yeah.
The ages of major offenders having the history that a child below the age of 12 is not criminally liable, then they are between 14 and 17.
14 and 17.
Yes.
So
although we've had younger than that,
okay.
but what happens to them, kuna file ingine inaitwa protection and care.
Yeah.
Now those ones we take them to protection and care. Mtoto anahitaji malezi bora na kulindwa, so that now wanawekwa chini ya mikono ya children officers to do another social inquiry report and to follow them up for a period of time.
For now, now that you've broken that down between 14 and 17, and you've said you have to ascertain that this child knew exactly what he or she was doing, right? So once you ascertain that, then what next for these kids? And my other question is going to be, is this because of lack of awareness? When we talk about, like, is it that they don't know that this is a crime? And you've talked about peer influence and the picking it from the wrong places. Don't they know?
Well, do children know they're offending? Yes, they do.
Yeah.
They know the difference between right and wrong.
Yeah.
And that is why there's that cut of criminal age of responsibility.
But also the other question, do they know the repercussions? Because right now, as we seated here, I know if I commit murder, I know there are repercussions, right? The repercussions to my actions. Now, when I'm rolling with a group, and you've talked about broken homes and the seeking solace in friends, and there's that element of they either they can't comprehend of the dire consequences of their actions. Is that even considered? Because you've talked about broken homes, ended up in the wrong company, they're probably in the streets, they're doing this to survive. Are those things that are considered?
Sorry. Let me give you a case scenario,
Yeah.
right? A child is arraigned in court. And again, we have to appoint a pro bono advocate and then send out a social inquiry to be done. Now, in the social inquiry, it will give us so much information about, number one, how the offense happened.
Yeah.
Number two, whether this child acknowledges that they committed the offense.
Okay.
Number three, what the community thinks about this child. Most of the time, they're like, aende tu, akae huko ndani, na hakuna ndani yenye tunampeleka. Because again, the law does not allow us to imprison children. This Children Act. Imprisonment is a last resort. Incarceration is the last resort for a child.
Yeah.
So then the community gives their own opinion. Now, when this child comes to court and you take them through the law, they have no idea of the extent of their actions.
Yeah.
When they were committing the offense, they didn't know that they would end up being deprived of their freedom,
Yeah.
that they will not probably go home that day, that they'll probably end up in a children remand home, that they'd probably be incarcerated for a brief period
Yeah.
as we await these reports, that
Yeah.
they'd miss school, They'll miss hanging out with their friends. They'll miss, and yes, another prevalent thing, they call it uraibu.
What's that?
Addiction.
Miriam.
Addiction.
Uraibu is zote na uraibu ni kama kuvuta bangi ama kitu kama hiyo. Yeah.
Addiction.
Addiction?
Yes.
Okay. Yeah. So like they'll miss all that. They'll miss their friends. They don't know that by the time they're doing this thing, they'll be on their own at the end of the day. So a week later, the child you see is not the same child you saw.
Yeah.
They're probably regretting that they committed the offense. They are remorseful. They are willing to change, and that is where something called diversion comes in.
Yeah.
Now, diversion is in the Children Act. If a child accepts their mistake and says, "I'm sorry, I did this," then we will not even read the plea to them. Hatutawambia unashtakiwa na hii kosa na hii. Tutawambia sasa, kwa sababu umekubali makosa yako. Now remember, they are acknowledging that what they did was wrong.
Yeah.
So this report will produce another thing called a diversion agreement, which will be prepared by the prosecution. That diversion agreement has 3 stages.
Yeah.
There's one that lasts 1 year, another one lasts 2 years, another one lasts 3 years. These are years of observation. You will be under the probation officer, under the community leader, under the chief. Kila mtu macho zake sasa zitakuwa kwako. Are you going to change or are you going to remain the same? And if you reoffend, you will not have the advantage of diversion again.
Yeah.
So from the short time I've been dealing with children, I have observed that diversion works.
Okay.
Once you place a child under diversion, now you've committed the offense of defilement. What you did was so bad. So you're giving you an opportunity to go and change. Most of them actually changed.
They do?
Yes. Even the ones that maybe decided to skip, they go back to school because you sign a comprehensive agreement. I'm not going to take drugs anymore. I'm going to be visiting the probation officer every month. I'm going back to school. I will work with the community. I will listen to my parent or parents, because most of them are now raised by their mothers or their uncles. Their mothers are away in UAE working.
Yeah.
So they have remained either with their uncles or their fathers. So I'll listen to them, I will obey, I will do this and this. So there's some sort of change happening in society, but bit by bit. Yeah.
On defilement, where another child has been defiled, right? Do you also still consider these measures? And you've talked about sodomy. You've talked
Yes.
about it's like a gang defilement, right? What happens in such a case? Do they also sit and say, I did not know what I was doing? And, they still go back to the society. But then there's also a child, another child, who's been deprived, something has been taken away from her.
From them.
Yeah.
Okay. Thanks, Miriam. Again, the beauty of the Children Code or the Children Act, it is so well structured. We can say no one is left behind. It is not like the other conventional codes where I'm done with the victim, I'm done with you.
Yeah.
But in the Children Code, we look at both the child in contact with the law,
Yeah.
and the child in conflict with the law. That other child, there is another file called Protection and Care, which shall be opened for the victim. This victim shall be taken through counseling. Orders are made. And I'm grateful that in this Mombasa, we work very well with the county government. There's the GVRC center at the Coast General Hospital, where we send our victims there for counseling.
Yeah.
There's the Tononoka Situation Room, where we send there our victims also for counseling. They go through a counseling session, maybe of 3 months, 6 months, and then the report comes back to court from the counselor. Please give me more time. I still need to talk to this child. We extend the time. Now, that victim does not get to narrate their story to the court again and again and again and again, which is so traumatizing. They get to end it there, where they now go for counseling. Yeah. That is only if this child, now the one in conflict with the law, accepts that I did something wrong. Now, if they accept they did something wrong, we also take them to counseling. Over and above the diversion that he's going back to school, he's going to change, he's going to do this, we also take them to counseling. So it's it will benefit both the child in conflict with the law so that they don't repeat, and also benefit the victim so that we don't have a repeat. Because in one of those cases, what we discovered is even the child that has now come to conflict the law was also defiled when he was young by another relative who was now an adult, but he didn't report. So he thought, this is something that I can also do to another child. But if the Children Act did not provide for this kind of social reporting, and we could not have discovered that bit. So then you counsel this child to understand that this is wrong.
Okay.
Yes.
All right. We are speaking to Honorable Nelly Kipchirchir. She's the Principal Magistrate, Tononoka Children's Court and Child Justice Expert. In a bit, we're also going to speak to Professor Sarah Kinyanjui. She's the UN Professor of Law, Advocate of the High Court and Criminal Justice Expert. And then also later on, Superintendent Jostinah Mwang'ombe. You know, she is the Superintendent Shimo Bostol Institution Juvenile Detention Expert. We are looking at child offending and the role of the community in this, as we also look at what the Children Act states. What question do you have? 0700917917. We'll be right back. Good morning to you. You're with me, Miriam Angel, Salim Barisa, and Emmanuel Gona. And of course, earlier on, we have been speaking to Honorable Nelly Kipchirchir. She's the Principal Magistrate, Tononoka Children's Court, Child Justice Expert. And you know what? It's a full house today. It's a full house today. We have been joined by Professor Sarah Kinyanjui. She's the UN Professor of Law, Advocate of the High Court and Criminal Justice Expert. Sarah, good morning.
Good morning. Thank you for having me.
You're welcome. Good to have you here. And we're also joined by, I've been told, Senior Superintendent Jostinah Mwang'ombe. She is the Superintendent Shimo Bostol Institution Juvenile Detention Expert. Good morning, Jostinah.
Good morning to you.
And welcome back.
Thank you.
All right, now let's go back to the conversation we were having.
Kuna pale awali ulikuwa umetaja kwamba kuna yule mwenye alikuwa amejipata akidhulumu mwenzake, lakini pia yeye alikuwa na hiyo experience akiwa mdogo na hakujua angeripoti vipi. Hizi cases ambazo zinafika pale, ni nani anaziripoti? Je, ni hawa wenye wameweza kudhulumiwa ama zinawafikiaje haswa? Kwa sababu nahisi kama yaweza kuwa kuna wengi ambao wanapitia, lakini hiyo channel mpaka zifike pale kotini pengine kuna issues.
Asante sana Hamisi. Leo ni kujago. Sorry, Salim. Sama.
Yes. Gone.
Oh, he's gone.
Yes, Salim.
Salim is here. Pole. Sorry for the mix up. Asante sana Gona. Kwa mara nyingi yule mtu mwenye anaripoti ni mzazi, mwalimu ama mtu yeyote mzima ambaye anapata kutangamana na huyu mtoto, halafu anagundua ya kwamba mtoto amedhulumiwa. Maybe mtoto ataambia mtu, sasa huyo mtu ndio mwenye ataripoti kwa polisi.
Langu moja hapa, kwa sababu ulipokuwa unazungumza ulitaja kwamba kuna wale ambao kwamba wanaweza akarudi kwa jamii huku, macho yao, kuna wazee sijui wale wenye watakuwa wanawaangalia during hiyo period ya, kwa sababu yes, alikiri na so amerudi pale mtaani, kuna kazi anaifanyia kazi ili kuona kama atarudi na amerudi shule. But kuna wale watu wengine ambao hawana imani na huyo mtoto. Kitu kama hicho huwa kinakuwa considered kama anarudi kule mtaani. Kama wewe mwenye anarudi shule, anarudi kule, pengine ni chief wa macho yake anamwangalia. But kuna wale watu, for example tuseme mimi, huyu alitumia silaha, alitishia mtu. So mimi imani yangu haiwezi kuwa as much as hao watu wengine wanajaribu kumrudisha, na yeye amekiri kwamba amekubali kufanya kosa na ako tayari kurekebisha. But now the society, do you hiyo mnaiconsider?
Katika ile social inquiry report,
Yes,
ambayo sasa ita result in diversion agreement,
yes,
ama makubaliano na upande wa mashtaka, kuna sehemu ya jamii itasema huyu mtu hatumtaki hapa, hatutaki aje kwa sasa, ama the society, the community is still so volatile, akiregeshwa maybe kutakuwa hivi na hivi. So hiyo pia itatiliwa consideration. Na wakati tunafanya ile diversion agreement, basi that will be one of the factors. Kama inasemekana hahitajiki kule, basi njia mbadala itatafutwa ya kusema maybe huyu mtoto atoke apelekwe kwa anko zake mahali fulani, maybe tuko tuseme Kisauni, apelekwe Kaloleni akakae kule kwa muda fulani. Part of zile measures za kuhakikisha kwamba ameenda kwa sehemu ambayo pia naye atakuwa salama, kwa sababu amekiri makosa yake. Na tutampatia ile nafasi ya kurekebika akiwa nje. Sawa sawa.
Okay. Now, Nelly, you said you do not imprison kids, right? No. You do not imprison children. But also, Jostinah runs a correctional facility. So who are these that are in Jostinah's correctional facility?
Okay. I'll just read the Children Act, Section 238. Restriction on punishment. No court shall order the imprisonment of a child. So we don't imprison kids, but we send them to the Boston institution for them to be corrected and rehabilitated. It is a rehabilitation center. It is not a prison.
Okay.
You get?
Yeah.
So once, and for us to send them there, they now have to say, I didn't do it. Remember, diversion is only open to those that accept their mistake. So if they say, I didn't do it, then the evidence shows that they actually are in conflict with the law.
Yeah.
Then we shall now send out another report called a pre-sentence report. How do we deal with this child who is in conflict with the law? If it happens that the offense they committed is so serious that it warrants being sent to a rehabilitation center, that is now when they become her guests. And their age will also dictate. They have to be over 15, under 18, up to 17. So they cannot be 14 to be sent to the Boston. There is an age definition, and I'm sure she will talk more about it. So that period which they are there, and the act that makes us send them there is so specific as to the period they have to spend there for them to benefit with the rehabilitation.
Okay. So Jostinah, what's the age bracket to the children or the kids that are sent to the rehabilitation center? And then also, for what period are they supposed to be there?
Okay, thank you very much. I don't run a rehabilitation center. I manage.
Okay.
It's a government institution under the Kenya Prison Service. We have 4 such institutions that deal with juveniles. 3 are Boston institutions. We have Shimolatiwa Boston Institution, where I manage or I head. Then we have Shikusa Boys Boston Institution, and then 1 for girls in Nairobi, the Kamai Girls Boston Institution. Then we have 1 called the Youth Corrective Training Center, which is also based in Nairobi but deals with children of the age of 17 to 21 years on admission, and they stay there for 4 months. For those who are sent to the Boston institutions, these are children who are of the age of 15 and below 18 years by the time their cases are concluded by the courts, and they must have committed offenses punishable by imprisonment. Those are the ones that we deal with. The children that are in need of care and protection are not processed in our institutions.
Okay.
Thank you.
What are these offenses? Because I know we spoke about defilement. We spoke about robbery with... Did you mention robbery with violence? Yes, we mentioned robbery with violence as well. When you look at those that are at Boston institution, what would you say is a common crime?
For now, for my institution, the highest number are those that are on defilement cases.
Okay.
Defilement,
And so for defilement, I'll take it back to Nelly, because Nelly says for them now to move to Boston, the evidence proves that you committed a crime.
Yeah.
And you you're stuck on deny, but the evidence proves that you've committed a crime. So when they come to Bostall, what is it that what kind of, is there a program? What is it that you do that would make them be in a space of realizing that I committed a crime? Are they able to accept that indeed I committed a crime and this is why I'm here for this period? Yeah,
thank you very much. When children are ordered, because they are not sentenced, they are ordered to come to our institution for rehabilitation and correction, we first receive them, and then we have a period of 2 weeks where we expose them to the regime of the institution. We normally have an open regime where all children, irrespective or despite of what they have committed, they enjoy all the rights and freedoms while in the institution because they are children. So nobody victimizes them, nobody separates them by the offenses they committed. We all put them together just like children are supposed to be treated. But in the 2 weeks, we expose them to some psychotherapy. We have experts who deal with them. We have social workers. We have a whole team of intake officers who are trained in how to interview children, how to make them understand their mistakes. And by the time they are 2 weeks old in our institution, they are able to tell the truth of what happened. And interestingly, when we now meet them during our reception boards, which happens after 2 weeks, where we meet them, I chair that board, and the section heads, the experts in the institution, we tend to allow the child to express themselves. The UN Convention of the Rights of the Child has that principle that the opinion of the child should count in all matters that concern them. So during this meeting, because we take advantage of the information that we have received or we have gotten from them during the induction period, to try and craft an individualized treatment plan with them. So we bring them in to interview them, to hear their stories. And I want to tell you for sure, when now they find themselves there and they are talked to, they are able to tell us the whole truth. And no child is put behind bars or in our institutions on who is on false allegations. They have actually committed those crimes. So they are able to tell us. We create just a safe environment for them to tell us the truth. And all of them, no one has come to our institution was either the crime was planted on them, they really committed those crimes. So during this time, we interview them. We take 30 minutes. We interview them. We allow them to explain to us. And we corroborate what is in the pre-sentence report. The courts, the Nelly's department, let me call it department, but the courts, they normally bring them in with a Bostall order. I mentioned that they are not sentenced, so they don't come in with a committal warrant. They come in with a Bostall order, which orders me and my staff to provide training to those children for 3 years. So when we look at the pre-sentence report, which advised or gave information to the court, which helped them now to commit the child to our institution, we look at what was written by the probation officers, taken to court, help the court to commit the child, and what the child tells us. We cross interview the child to find the facts between the lines on the report that was brought in with the child during admission. So it is from the pathways that we get from this report and what the child submits to us that we develop the individualized treatment plan. The individualized treatment plan runs for 1 year because the Bostall Act Chapter 92 allows a child who has stayed in our institution for 1 year, that is 12 months, to go home early. Remember, the incarceration of children should be the last resort. And if it happens, then it should be for the shortest time. So for us, Kenya Prison Service, we are guided by the Chapter 92 Bostall Act to allow children to go home early. Not like opening the doors and telling them just go home. There is a whole regime, we call it through care procedures, which we follow, that we write reports to the probation officers who wrote the pre-sentence reports in intervals of 4 months, 7 months, 9 months. Then using the progress reports, they reply the reports with what we call the environment adjustment reports, which is actually the factors in the community which pushed the child to crime, which are monitored, and they are also intervened. There is some intervention that happens with the probation officer, so they put it in that environment adjustment report.
Jostinah, in a minute, so you have them for a year, and then you've also mentioned a period of 3 years, right?
Yes.
those that have finished the program,
Yeah.
when you release them now
Yes.
to the public, right? How are they able to fit in, and how different are they from the ones that joined your program?
Come up again.
Like when now they've gone through the you've said it's a rehabilitation center.
Yeah, it's
right?
a rehabilitation.
So
yeah.
after rehabilitation, you've said 3 years, but then within a year,
We can release them.
You can
on
release them.
license. We
Yes.
call it release on license.
if they're of
Yeah.
good conduct,
Yeah.
right? Now, when now you taking them back to the community,
Yes.
right? How is the inception, and then also, have you found instances where some of them become repeat offenders, or are they completely different?
Yeah, what I can say is that our program is not perfect. Like I
Yeah.
can't report 100%.
Okay.
We have some few who reoffend, recede, and they come back to our institution. So as I was telling you, when we receive now these environment adjustment reports, if they are congruent with the progress reports and the child is willing to go home, we release them.
Yeah.
So at 12 months, as I mentioned, we release them as a privilege to them, as a part of the law. If that's how we effect the law that children should stay for the shortest time.
Yes.
You've asked me how do they respond,
Yeah.
like when they go back, do they recede? Or when we release children after 12 months, we release them on license. What does that mean? There's a license that I sign as the superintendent in charge on behalf of the Commissioner General, and this license I issue it on advice by a board called the Board of Visitors, which is chaired by the PS in charge of correctional services.
Yeah.
So once the children are approved to go home early during this board meeting, we call them board meeting, we hold them quarterly in February, in May, August and November. We give orders in that license that the child should not reoffend, the child should not go and get back to the pro-criminal peers and the rest. So once they go and contravene the orders, they are recaptured and brought back to us without going back to the court.
All right.
Yeah, remember the child had 3 years. So the child went home with less 2 years. So the remaining 2 years, they are supervised by the probation officers who developed the pre-sentence report that advised the court to bring the child to us. So there is this synergy in
Yeah.
the way we process the children.
Okay.
Yeah.
We are looking at child offending and also the role of the community with an understanding of the Children's Act. In studio, we have Jostinah Mwang'ombe. Jostinah Mwang'ombe, she's the senior Superintendent Shimo Latewa, Shimo Bostol Institution, and also Honorable Nelly Kipchirchir, she's the Principal Magistrate, Tononoka Children's Court, and Professor Sarah Kinyanjui, who, when we come back, will tell us more about the Children's Act. Good morning. We are looking at child offending and the Children's Act, and then also the role of the Children Act, and then also the role of the community in all this. In studio, of course, we have Jostinah Mwang'ombe, Senior Superintendent Jostinah Mwang'ombe. She is a Superintendent Shimo Latewa, Shimo Bostol Institution. And we also have Professor Sarah Kinyanjui. She's the UON, University of Nairobi Professor of Law, Advocate of the High Court, and Criminal Justice Expert. Sarah, before we get into the Children's Act, let's talk about the role of the community in all this. Who's failing the kids? Who's failing the children? Because we need to decongest Bostol Institute. We need to ensure that Nelly has minimal cases before they get there. Somebody is responsible. Who?
We all are. And just on a light note, we are not rejecting the Children Act. We're not rejecting it because the Children Act speaks of the role of the community.
Yeah.
The community is failing. And it's all of us.
Yeah.
Actually, when we conduct research in different facilities, first allow me just to talk about the different facilities. Of course, it's a Bostol institution, but there's also other institutions that we call rehabilitation schools. We previously called them approved schools. Those are run by the Directorate of Children's Services. And when we do research in those institutions, the kids repeatedly say that, number one, our parents are failing us, the community is failing us. A lot of the kids in our institutions are as a result of the circumstances, their home environment, it is what is pushing them to commit these crimes. And of course, when you talk about being soft on children, we are taking into account that these children have found themselves in the circumstances that they are in, and we need to take responsibility. So the community has a big role to play. And so the Children Act now introduces the role of the community in responding to crime. Yeah. So we are all failing. The schools, the religious institutions, the families, we are all failing.
What could we do better?
Gosh, I think everything. Number one, I think the first thing that we need to realize from a parental perspective is that we need to spend more time with our kids. It's interesting that kids point out that we are no longer at home. And if we are home, we are concentrating on other things. And so our children who are developing do not have the privilege of being guided by present, emotionally and physically present parents. So that's number one. I think at a parental level, we need to be there. At a school level, I think we have concentrated on the academic development even more than character development. So at school level, we need to reorient our education to think about character development. At a religious level, I think we are just focusing on the larger outcomes. Are we growing in numbers, etc.? But we're not focusing on the individual child. So we all need to really think about how these children are developing in terms of character. So character development is key. And when you look at the Children Act, for instance, when he talks about, and you kept asking, Jostinah, we don't imprison. And the reason why the Act does not talk about imprisonment is that we take into account that children are still developing. Their brains are still developing. And so when they commit crimes, we look at it as a developmental issue. And so therefore, as a community, we must start thinking, how then do we ensure that they develop in a manner there are people of integrity and people of good character?
Okay. So what then does the Children Act seek to address?
So number one, allow me also just to say at the beginning that the Children Act is not just about criminal matters. The Children Act talks about a holistic approach to children. You're talking about social issues. You're talking about adoption. You're looking into children in need of care and protection. If you have children in the streets, what do you do about them, etc. But there is a specific component on children in conflict with the law. We call them children in conflict with the law, not criminals. And so there's a section that addresses that specifically. And so what it does, it looks at the whole continuum. So you've arrested them. Initially, you'd arrest them and take them to court, but it has introduced something new that we are referring to as assessment. So the police officer is supposed to call the children's officer to come up with a report about the home environment of this child. So we start looking at the circumstances from the word go. What is really causing the child to offend? And so by the time then they go to court, there's already this report from the children's officer, and then the court initially would go ahead and take plea. But we no longer do that. The Children Act now requires, before they take plea, then there's a preliminary inquiry. I don't know whether Honorable Nelly had spoken about the preliminary inquiry.
She did.
And so again, the idea is find more about this child and see whether they can be diverted. Allow me also just to say that when you talk about diversion, it's not a soft approach to crime, because the community really gets offended when you've reported a child and then you see this child back into the community. So it's not a simple approach to crime. The intention is that we go back to the community. We are the ones that are contributing to offending. We are the ones who have to resolve. So we are not throwing the issue to the government, but we take you back to the community that has contributed. So when you're diverted, there will be, for instance, a family conference. A family conference is not just the family. You can have members of the community. And you know, when you're asking about a hostile community, it's at that point you rope them in so that they also begin understanding why is it you would want the child to come back to the community. And apart from that, then you also have responses. So you won't just take the child back to the community. You'll ask yourself, what caused the offending? If it's something that needed counseling, who are the community counselors? Can we get counseling for the child? If it's an economic issue, they stole, what is the child lacking and who can assist.
All
So we
right.
begin going to the root causes of the offending. So the Children Act incorporates this.
All right. Thank you so much, Professor Sarah Kinyanjui. We are running out of time, but thank you so much for breaking it down. It's just a brief understanding of the Children Act and also an understanding of what the Senior Superintendent, Jostinah Mwang'ombe, does when it comes to, how do you call it, rehabilitating the children, rehabilitating children, and then also taking them back to the community. My take home from all this is that we are all responsible. Yes, we're all responsible in molding our kids as parents. It begins with us, and then as a society, it also begins with us. And so I would wish we'd see a space where we decongest the prisons. You know, we decongest Boston Institution, we decongest Nelly's Law Court, right? And position these kids in a different way. Thank you for making time. We have been looking at child offending and Children Act, and also the role of the community in all this. Take home again. When a child is in conflict with the law, we don't call them criminals.
That's right.
It's a child in conflict
Yes.
with the law.
And we don't sentence.
We don't sentence. Good